Welcome to Clause 8. You're watching a short clip from one of our full episodes, featuring real conversations with the leaders shaping IP.
I guess one of the ways the patent system was reined in by the Supreme Court that I guess has impacted the pharma industry is on 101 patent eligibility.
Yeah.
And the timing of the interview is pretty lucky because you actually testified on that subject this week. So we're recording on October 10th. It's been 13 years, I guess, since those series of cases kind of started. At the hearing, you mentioned that you testified 6 years ago, I guess in 2019, when they had those 3 days of hearing about patent eligibility. I think it was something like 45 witnesses, and they were making a big push. But you said since then, since they put in all that effort into highlighting the huge problem about what has been done with patent eligibility, things have gone from bad to worse. I guess, can you tell us about that? And I guess why has that happened?
Yeah, I mean, so quick background for people who don't really know the whole issue. I mean, the U.S. has always had a very, very broad, historically, very, very broad set of patent eligibility laws under what's now codified in Section 101 of the Patent Act. This, of course, is what defines what types of inventions in general, right? Not particular patents, what types of inventions can be subject to the patent system in general, right? So there are certain things that are outside there. I mean, a work of art, right? That's copyright. That's not patent. So, of course, you need to have some kind of explanation. And since the beginning of this country, there have been certain categories that are patent eligible, processes and manufacturers, machines, and compositions of matter. These have all been in since the 1790s, things that are patent eligible. And there have always been these kind of exceptions that have been implied by the Supreme Court law in the early days of the country, which they called products of nature, natural laws, and abstract ideas, right? The thing is, these were historically defined as exactly what they sound like, common sense things. So product of nature, and this was talked about at the hearing, right? An apple on a tree. One of the senators mentioned this, that's a product of nature. So someone can't find an apple and say, I'm going to patent that. It's not eligible for the patent system because it already exists in nature. Fine. The law of gravity. This is in the case law, by the way. A new plant in the wild, a new mineral in the earth. The law of gravity equals MC squared. Those are the four kind of archetypal examples that the Supreme Court used to give for the implicit judicial exceptions. And what happened in this trilogy of cases, Alice Corp, Myriad, and Mayo in 2011 through 2014, I think they were, they basically really changed what these cover. So rather than a law of nature being like gravity, suddenly a diagnostic method of correlating different levels of a drug in the blood with a condition in the body was considered a law of nature in a patent claim. It's a huge step, right, from a natural truism to that. On the gene space, we went from a mineral in the earth to a gene that's extracted through chemical isolation out of the genome, right, to make a new chemical entity, which is a composition of matter, by the way, by definition. Scientifically, you take a gene out of a genome, it's a new composition of matter. But they said isolated genes are not eligible. And then on the abstract idea side, which is not really our set of issues, they said a lot of software under the Alice Corp case is not eligible. So that was 2019. That's what I was referring to about we were concerned then. What's happened since then, to your question, is we were worried in 2019 that the test itself that the Supreme Court had is so vague and broad the way it's applied. We don't have to get into the details here, but that it would keep spreading to new subject matter. So it's bad enough that the Supreme Court has now moved from these universal constants into things that are actually, we would consider forms of technology. But if it's going to continue to morph and the target is going to continue to move and expand into more and more subject matter that's no longer eligible for the patent system, this is going to start cutting into the core of the cutting edge fields that matter to the future of medicine. And that is really what the case I talked about, which is a case that was just heard earlier this week by the Federal Circuit, is a case that involves cultured host cells, genetically engineered in a laboratory, that include DNA, recombinant DNA, which if you're not from that field, what that means by definition is that it's combined from two different sources that don't exist in nature. In this case, it has to be, this claim itself specified, two different species spliced together into a genome that doesn't exist in nature, put into a cell that doesn't exist in nature, and it's useful in creating the viral vectors that deliver genes to patients who lack them in gene therapy. So now we're talking about a huge shift, in other words, from even isolated genes, which you can debate, whether or not those should be eligible. But now we're not talking about genes. We're talking about clear applications of genetic material where everyone, including the defendant in that case, agreed does not exist in nature. And what that means is, and let me just say one more thing about that. In the reasoning of that case, the district court judge said, well, the way I read the law is if you take components of nature and you combine them into something that doesn't exist in nature, that's not enough to be patent eligible.